so we're just going to start off. The first question, can each of you please describe the organization you work for, what it does, and who they serve?
Thank you, Blair, first for inviting me to come here today. I am with the Public Guardian's Office. I'm the Assistant Public Guardian. I have many years of public service, starting out with the District Attorney's Office. Then I went over to County Counsel's Office. And while I was at County Counsel's Office, I was assigned to the Public Guardian for about 12 years before I crossed the tracks and became a manager at the Public Guardian's Office. So, Public Guardian's Office, we call it a small and mighty team. We have about 14 deputies who are the fiduciaries, the conservators, and we have support staff, a couple of other managers besides myself, and we have our fiscal department, and that's about it for our team. But and then our legal processing team as well, because we file a lot of court documents. I would say on average about 150 court documents every month. So there's a lot going on in the Public Guardian's Office. So just briefly, I'm going to let you know our programs we have. We are in the middle of a transition. I had passed out this Public Guardian flyer. If you notice, it's not in print form yet because this was just created on February 18th. So I printed it out. Yes. The Public Guardian's Office for many years was housed under the Human Services Agency. And as of February 18th, we have now transitioned under the Health Care Agency. So hence this trifold brochure. Anyway, so our three programs, or our main programs we have our probate conservatorship program, which I think we're going to really base our conversation today on. And those are reserved for our elderly population, our most vulnerable population, who may be susceptible to to financial abuse, yes, to financial abuse, or they just need help managing their medications, getting to their appointments, and so forth. Also in that program are our developmentally delayed folks, as well as individuals with traumatic brain injury. In that program, we currently have about 145 conserved clients. On the other program is our LPS program. Those individuals are deemed gravely disabled, and they're adjudicated in the Superior Court as such. And it is they're gravely disabled due to a very serious mental illness, usually schizophrenia or schizoaffective. And due to that mental illness, they cannot provide for their food, clothing, or shelter. And we have about 240 conserved clients in that program. And I'll talk a little bit more later on the differences between those two. The third program is our subpayee program, where individuals who have a mental health issue and they're open to behavioral health with the county, and they just need help with their SSI, with their placement, with their Social Security benefits and payment of rent, and we become their subpayee. And that is actually run not by the Public Guardian. We kind of house it with a fiduciary with their money, but it's really managed by the behavioral health case managers. So those are our three main conservatorships. We have one offshoot, which is those defendants who are held incompetent to stand trial, and they have an underlying felony or misdemeanor. And due to that, the court will have the investigative body, us, the Public Guardian, investigate whether that person is appropriate for a probate conservatorship, an LPS conservatorship, or a Murphy conservatorship. And Murphy is when they have an element of dangerousness. So their underlying felony criminal proceedings are stayed, and they're put on a Murphy conservatorship. So all of that is also in our flyer, in our brochure, but that just gives you a little idea of who we are, okay?
Hi everybody, I'm Chris Young. I know a lot of you and looking forward to knowing more of you if you have questions today. My firm is the Alvarez firm, and if you haven't heard of me, you may have heard of our firm. Now one of the larger firms in Ventura County. But we focus on real estate, business, and estate planning. So a lot of the original intent of the firm was to serve small businesses and entrepreneurs. But then I came on board about 12 years ago, and my background is in elder law. And so the firm said, wow, instead of referring out conservatorships and special needs trusts and things having to do with veterans work and Medi-Cal questions and things like that, let's have that in-house. So I brought that component into the Alvarez firm, and so I guess you could call me an elder law attorney, but it's very closely connected to estate planning because estate planning is always a component of good elder law, and estate planning attorneys would tell you elder law is a component of estate planning, but whichever way you look at it, they're very closely connected. But our firm has our main office is Calabasas, but our local office here is Camarillo, right behind the Trader Joe's, just a few blocks back. And then we also have an office in San Juan Capistrano, which is very, very nice, but also very expensive to live down there. So I'm very happy to be here in Camarillo. I live just about a mile away. And this is, if you come to our Camarillo office, this is primarily where you would meet with me. The Alvarez firm, we have about 11 attorneys now and then a bunch of staff. And if you have questions about anything having to do with the law, I gave out my cards. There's some still on the back table. Feel free to just give me a call or shoot me an email, because if we don't do that area of law, I know people that I trust that I can put you in touch with, good people, instead of just kind of looking online and hoping for the best. So please keep me as a resource no matter what. As far as what we do and what we serve, who we serve in the realm of conservatorship, we work with private clients who are in a position to hire an attorney to help somebody who needs conservatorship. And a lot of times that is in direct juxtaposition to what who Diana works with, because many of the people I would say that Diana's agency works with are people that have nobody that can step up. Or maybe they have somebody, but they just have no means to hire an attorney. And I'm sorry to say, a sad reality of just private practice attorney work and the amount of insurance that we have to carry and the work involved and whatnot, we're not able to be very cost effective for some people. I mean, we try to be cost effective within the county, but it does cost money to hire an attorney. We all know that. So when people have the means to hire private counsel to help, then our firm is often one that's approached. I also help with the local court here in Ventura County, as what's called a pro tem judge on occasion on conservatorships. So when the judge is out of town or on vacation or something like that, there are times when I may be one of a number of attorneys that get asked to fill in. So that's another area in which I assist with conservatorships in this county. And interestingly, in those cases, I may actually be involved in cases in which Diana's office is involved, because we all come together in court on the same days to have our hearings heard, primarily on Fridays for new conservatorships. Just keep that in the back of your mind. If you ever are petitioning for a new conservatorship, it would be on a Friday morning. And then ongoing conservatorship matters are usually heard on Tuesday mornings in Ventura County. And I also practice in Santa Barbara and LA and Orange and all of the counties in Southern California to some degree or another, but primarily Ventura County, LA, and Santa Barbara. So that's the first question.
Okay.
We'll get to more, but that's the first question.
Okay.
All right.
So you kind of answered a bit of the second question, but can you discuss the process of obtaining a conservatorship for a loved one? And is there any difference between a conservatorship and a guardianship?
Let me handle the last question first. Guardianship in California, and I didn't mention this, I'm also licensed to practice in Oregon. So that offer applies to Oregon too. If you need an attorney in Oregon or anyone you know has property up there or something, I can help refer somebody in Oregon as well, or perhaps even answer the question myself. But I'm an Oregon attorney, and I mention that because in Oregon, guardianship is where we help adults with their personal needs, like their medical decisions, where they live, etc. In California, that is called conservatorship of the person, okay? But in Oregon, it's called guardianship. And in many states, you'll find that guardianship refers to adult conservatorship of the person. Here in California, guardianship is exclusively reserved to minors. So we think of time, who's going to become the guardian for a child who lost a parent. That would be done in either family court when there's maybe a dissolution of a marriage involved, or in probate court when there's been a death of a parent. That's guardianship. So up to the point of 18, guardianship. Many children who are under guardianship then graduate at age 18 and no longer need that. Others who have disabilities, developmental disabilities, may continue to need conservatorship after they turn 18. So that guardianship may transition to a conservatorship. But that's the main difference between guardianship and conservatorship here in California. So when you read it on Wikipedia, there's going to be confusion there because every state's different. That's why I brought up Oregon. But here in California, children are under guardianship, adults are under conservatorship. And then I touched on one of the different distinctions within conservatorship, and we're going to get to a lot more of that, but it might as well start now to talk about the different types of conservatorship. So Diana mentioned that her office handles probate conservatorship, which is the conservatorship we think of when we're dealing with elderly folks, people that are maybe have dementia. They're not going to get better. This is something that's for the rest of their lives. They're going to need the assistance of someone else to kind of step into their shoes legally. That's probate conservatorship. And within that are two different types. Conservatorship of the person that I touched on, that's the guardianship type conservatorship in other states, and conservatorship of the estate. And that is, as it sounds, that's protecting their finances and their financial well-being, looking out for that. So the two often go together, but sometimes you will find a conservatorship of the person only or a conservatorship of the estate only, depending on the circumstances in that case. There are other types of conservatorship. Diana also touched on a couple of other ones. The one that she'll talk more about later is the one having to do with gravely mentally disabled individuals. Her office is very involved in those. That comes under the Lanterman-Petrus Short Act, the LPS conservatorship, so she'll talk more about that. And one that we both work on, and maybe me to a greater degree because I work with a lot of parents who are trying to help their developmentally disabled children. That's called limited conservatorship. So limited conservatorship, different from probate conservatorship, because it's primarily focused on developmentally disabled individuals, people who had a disability growing up, and then they need continued assistance once they become adults. All right? And it's a very confusing area of law, and there's a lot of terms that we're throwing at you, but the way to think of limited versus general is the rights of the individual, the conservatee, are removed by the court and placed in vested in their conservator. With limited conservatorship, that only happens with up to 7 specific rights. 7 specific rights, which I didn't think to print, but I can quickly go through them with you. The right to control the education, the medical, this healthcare decision making, where that person lives, where that young adult lives, to have access to their confidential records, their ability to contract. And then here are the two most, I would say, controversial ones that come up, but the last 2 of those 7 are the right to control their right to marry and who they marry, and the right to control their social and sexual contacts. Okay, so that's 7 powers that are involved in a limited conservatorship. So only those powers shift, or the ones that the court grants shift to the conservator, and everything else stays with the conservatee, the young adult usually in that case. So, and the court doesn't always grant all 7. Sometimes you'll see 3 or 5, and in our county, very often all 7 are granted, but that's not always the case. So that's limited conservatorship. And why is it limited in that way? Because the idea with limited conservatorship is we always hope that that person will graduate out of conservatorship, that they will become able to manage their own finances or their own decision making on their own. Whereas with probate conservatorship, we assume that that's never going to happen, that they're going to need the assistance for the rest of their lives. So those are, have I done an okay job with those? Okay, it's a lot of information. And I just want to touch on one more thing before I hand it over to Diana. I try to think of an example with people because I get a lot of calls saying right off the bat, I need conservatorship for mom, or I need conservatorship for dad. And I spend a good part of my day talking people out of conservatorship. And the analogy I use, and I understand it's not that great, but it's the best I've come up with so far. If you have a better one, please feel free to share it with me. But we all know what bankruptcy is. It's a set of laws that are there for us if we absolutely need them, but we do everything we can to avoid them. And I feel the same way. I say conservatorship is the bankruptcy of elder law. It's there. We know it's there. It's there if you have absolutely no alternative, but we do everything we can to avoid it. And we'll talk about some of the ways that we can avoid it with proper planning ahead of time, or even maybe a way to avoid it even in the moment with what's a new thing that's come about in the law called supportive decision making that is really being pushed as an alternative to conservatorship. So we'll talk more about that as we go along. But the key thing is we avoid conservatorship and we only do it when it's absolutely necessary. And that's not just me saying that. Here's the deal. The court will not grant it unless there's no alternative. The constitutional term they use, and this is a constitutional rights issue because people are having their rights taken away. The right to vote is sometimes taken away. All of these rights are removed, and so they have to go through a process of finding that there's such a need. And so it must be, and here's the term, the least restrictive alternative. That's a constitutional term. The court has to find that there's nothing out there that can do a better job or a less restrictive job than conservatorship. And if there is something else out there, you got to try that first. So without grandstanding or filibustering, I'm going to pass it on to Diana, fill in any holes that I left there.
So I was just going to point out some of the differences between an LPS conservatorship and a probate. When somebody is placed on a probate conservatorship, it's usually for the duration of their life. So out of the 140 some cases we have, we'll probably keep most of them until the day they pass on. And we have a lot of the limited conservatorships that Mr. Alvarez was talking about. A lot of times the parents age out themselves and the daughter or son still need assistance. So we come in and the court appoints a public guardian as a neutral entity to take care of the conserved client. But one of the main differences is for probate, anybody could make a probate referral, a neighbor, a church member, a teacher, a friend, a relative, a coworker, just about anybody. With LPS, those are initiated only by the Hillmont Psychiatric Center. So they're coming to us from the hospital, right? So that's one of the main differences. The other is for LPS, there's a statutory requirement, the grave disability statutory requirement, that they have to be deemed gravely disabled due to a mental illness. They cannot provide for their food, clothing, or shelter, or accept meaningful treatment. In probate, the standard is less. It's basically they need assistance, they're unable to provide for their personal needs or manage their financial resources. Placement for LPS, we get locked right off the bat. For probate, we do not. We can get an extra dementia power for a secured perimeter placement when we have individuals who suffer dementia and might be a wandering risk. We could put them in a secured placement. But for LPS clients, we get locked placement right away. The duration for LPS is 1 year, so we have a 1-year renewal process for those folks. So the plan is, or the encouragement is, that they will gain insight, if you will, to their mental illness or continue to be medication compliant, go out, get jobs, and be able to take care of themselves. A lot of times, they can get off conservatorship, and sometimes it doesn't work out, and they come back. But we get a lot of those too, that come and go, but we're always there. Like I said, probate is indefinite. Both of them have a right to a hearing. So for probate, when a probate conservatorship is established, the proposed conservatee can go ahead and request a court trial. If there is a capacity declaration that they lack the capacity and suffer dementia, the court will automatically appoint a public defender as their attorney. In LPS, they also get a public defender, so we have two different sets of public defenders. Public guardian, we represent we're represented by our county council, so they represent us in court. Let's see, basic powers, like Mr. Albert said, for probate conservatorships, you can have probate conservator over the person and the estate, or one or the other. Usually LPS is both. We usually get both powers right off the bat. LPS, we do not get medical powers, so if somebody is suffering, if they need a biopsy, for example, and it could possibly be cancer, but that client refuses to go see a doctor, even if it's part of their delusion, we can ask the court for an order to take them to get their biopsy done, but it's just a court order. And when they get to see the physician, if they are adamant they don't want this done, then it's physician client, and they won't get it done. But in probate, we do have medical powers, right? So, and we consent to a lot of medical procedures. If a medical procedure, the risk assessment is high, let's say somebody has an aneurysm and they need to get it operated on, well, there is a good chance that something may go seriously wrong in the procedure. What we like to do is, even if we have the medical power and authority to consent on that, we like to go to court with that, so everybody's on the same page. The judges, the public defender who represents our client, and then we can get a court order for that. And of course, all LPS clients are confidential. Those hearings are closed to the public, unlike probate conservatorships. So I just wanted to touch on the difference between those two.
Can you please discuss the advantages and disadvantages of conservatorship?
Sure, I can take the first crack at that. And I just wanted to touch on a couple of contrasts with what Diana just talked about when we're dealing with probate conservatorship. First of all, the confidentiality. Part of the planning ahead and avoiding this is not to have, all of your information, and sometimes very private information, disclosed. But it is a public process. It's part of due process is to have, a public hearing about these things. So you can, if you're so inclined, you could actually go to the courthouse on the days I just mentioned, Tuesday and Friday mornings at 9 o'clock, and you can see what a conservatorship hearing is like. That may be of interest to people from a civics perspective, but it's also just a function of the fact that this area, with the exception of LPS conservatorship, this area is public, and a lot of private information or things that you would think would be fairly private are discussed in open court. So that is an interesting. I would call that a disadvantage of conservatorship, as long as we're talking about advantages and disadvantages. I've hinted at this, but I think that there's many, many disadvantages of conservatorship just from. If it should be avoided if at all costs, if possible. But I did want to start by just saying that there's one advantage, and again, this comes partially from just seeing other people that are involved in conservatorship, seeing the people that come to court to try to help their loved ones, and that is, you really see the good in people in conservatorship court. In many, many cases, you're seeing people out of the goodness of their heart children who have perhaps been mistreated. I'm thinking of specific cases that I'm not going to name, but children who have been mistreated by their parents who are now stepping up financially and with their time to care for that person. Perhaps they've had a mental illness their entire life that contributed to that, but here they are doing the right thing. Parents who are continuing, recognizing this is a lifelong vocation for them. To a lot of parents at 18, they get to say, right when you have grandchildren, right? But for the rest of these parents, this is a daily commitment that they make to their children to shepherd them through life because they have a developmental disability. So I am routinely impressed by the good that I see come out of conservatorship, but it's not to say that it's not a difficult, there's a double negative. It's a very difficult process, no matter how you approach it. I would say it's simpler if you have counsel or experienced people involved, but it's still a difficult process. And let's talk, because Blair had asked an earlier question about how to obtain a conservatorship, and I think it's worth touching on some of the documents that Diana has talked about here. She mentioned a capacity declaration. So you have a sample capacity declaration it was on the back table and handed to you. This is a form. In this area of law, we refer to our forms by number because it's just the simplest way to do it. So this is the GC 335, and you see it in the upper right corner, and that's called a capacity declaration. This is a document that has to be filled out in almost every conservatorship case. And if we're talking about probate conservatorship, the last page, it's an additional page called the 335A that really needs to be there if there's dementia involved. So if you are ever going to seek conservatorship for someone, and perhaps you're going it alone, or you're doing it with and I should mention that in the the courtroom for conservatorships is on Vineyard in Oxnard. It's the juvenile courthouse, the newer building that they have there on Vineyard when you're almost out to Central, and or the 118. And that courthouse has one courtroom that's dedicated to conservatorships, and that's courtroom 6 on the upstairs. When you go all the way to the end of the hallway, that's where conservatorships are heard. So across the hallway from the courtroom is a self-help center. And that's staffed with good people, very busy people, but good people, and they have bilingual abilities, and they can help people try to do this themselves, how to fill out these very complex, very non-intuitive forms that we have. But one of the first steps I always have clients do when they're considering conservatorship is to take this to the doctor and ask them to complete it, because this tells us a lot about the situation and whether conservatorship is even warranted. There's a whole process. Again, it's a little arcane, but of the checking boxes to determine whether there's memory issues, whether there's other types of issues that would lead someone to need conservatorship. And the court needs to hear some medical evidence. The one exception I can think of is if you're just seeking conservatorship of the estate. If you're just going in to protect somebody's money, technically the court can proceed without a capacity declaration. They just need evidence that there's maybe some undue influence or elder abuse or fraud going on, and they can start the process at least. But the judge always wants to, if at all possible, get some medical evidence, and this is the main way to do that, okay? If you can't get the person to go to court or to go to the doctor, and many cases involve people who are in denial about their health care, so they don't go to the doctor, they don't have a regular doctor, then the judge can also order them to, like Diana mentioned, to go to the doctor. Also, if the doctor's concerned about privacy, you can get an order to complete one of these so the doctor has some legal cover to fill it out and submit it to the court and not worry about the privacy laws as much. So all of these things, I would pick this up, look at it. It's really enlightening as far as the questions the court asks. And all of this is pulled from the statutes on conservatorship and what constitutes capacity. And so take a look at that and feel free to take one home. Another really vital form that you have to fill out is this GC 312, which again, it's the upper right corner. And this form is we call it the confidential supplemental information. When you file a conservatorship, 2 files are open with the court. There's a public folder and there's a private or confidential folder. And the 2 documents I'm holding here go into the confidential folder. That's something that if you went down to the courthouse and asked for a copy of the file, you would not get these. You have to have specific reasons and justification for getting them. So this confidential supplemental information form was just updated in January. So you can see the revision date at the bottom. And it's become much more specific about the things the court needs to know about. And there's a whole section here on page 3 about all the alternatives to conservatorship that you've tried. And you have to explain to the court why those alternatives have not worked or are not applicable in this case. The court also wants to know very specifically about how the person is able to provide for their personal needs. It's not enough anymore just to say they need help with their personal needs. You've got to get into specifics about their ability, their physical health, their ability to make and consume food, their dress themselves, give themselves shelter. All of those activities of daily living need to be addressed very specifically in this form, and you can attach attachments. There are times I have filed this form with 10 pages attached of additional information. This is the time to get very specific in a confidential way with the judge. And also, when Diana mentioned when a petition is filed, the court will appoint an attorney. The public defender is appointed for cases that involve conservatorship of the person, and many times conservatorship of the estate as well. But they have a new thing in Ventura County where if you have enough means, the court will actually appoint somebody, a private attorney. The judge has a list of private attorneys who have qualified, and so he may appoint a private attorney instead, because the public defender is very, very busy. And so if a case comes in and the person has substantial wealth, then the court would want to have a private attorney represent them. So just know that that's one distinction. But again, this is the private, whoever the attorney is that's appointed, and an investigator from the court will all look at this document and learn from it as well. So keep in mind who you're writing to when you complete this. So as a first step, the question that Blair asked a long time ago was, what's the process of getting this going, or what's to establish a conservatorship? And these are the first 2 documents that I give clients to start the process. Give it to the doctor, and then start telling me about these things. And then we'll put it in a fashion to submit to the court. But these are the questions we need the answers to right off the bat.
So our process with the public guardian is just a little bit different. So I had handed out the referral for probate conservatorship. It's a 5-page form. When you go to the Ventura County Behavioral Health website, that's on the brochure.org, there's a section there under service, and if you go to the public guardian, you'll find this document, this probate referral document. So all that's required for the public guardian to receive a referral is this document and the capacity declaration. The CSI, or the confidential supplemental information, is something we do in-house, and that's when we decide whether a probate conservatorship is appropriate and least restrictive. So when we get a referral, we're mandated to start our investigation within 48 hours. And our investigations usually last about 30 days. And at that time, we roundtable and decide, A, does this rise to the level of a probate conservatorship? And B, is this going to be conservatorship over the person, over the estate, over both? Or does it rise to a temporary conservatorship? Regular conservatorships, when we petition the court, the hearing is not going to be set till at least 90 days out. If there's a reason to go in and get the conservatorship established beforehand, then we would file for a temporary conservatorship. And there really has to be a good, solid reason why. The public guardian also has authority on the probate code to freeze bank accounts if somebody's loved one is taking grandma's ATM card and going wild. We could stop that. And even if there is no petition on file, but if our intention is to file a petition, we could freeze that account. We could also prevent foreclosures from happening, evictions, so we have the power to do all of that. We cannot liquidate anything. We could only put a Band-Aid on assets until the conservatorship is established. So this and the referral form, there's a lot of questions that we ask. It doesn't all have to be filled out, but it assists us in the investigation. If you know more about this person that is the proposed conservatee, just put down everything you can. Sometimes there might be a trust, right? So I think this person has a trust. Maybe their house is in a trust. A conservatorship alone, when it's established, does not give us the authority as a successor trustee on a trust. So sometimes the alleged perpetrator is the successor trustee of the trust and already put the house in their name and so on and so forth. So besides getting the conservatorship established, we will ask the court to also become successor trustee of the trust, right? So anyways, that's an important distinction to be made between you wanting to be the conservator and then having the public guardian be the conservator. Another thing that Mr. Alvarez was stating is that once we petition the court after our investigation, the court does their own investigation. So they will do some of the same things we do. We talk to all the relatives because we are the public guardian. We're the last resort. We're the bottom of the barrel. When it comes to priority, there's 10 people above us, right? We're always the last resort. So we need to make sure there isn't a relative out there who wants to take over or that is the least restrictive. And then the court does the same thing. They will interview all the relatives, even if the relative is estranged, it doesn't want anything to do with the proposed conservatee. We still have to notice the conservatorship being established. We still have to serve paperwork. Maybe a relative is incarcerated. That's not going to stop us from our notice requirements. So we need to notice, I think, to the second degree, right? To the second degree relatives. So we have our search engines that we have in the public guardian's office, and we try to find all the relatives. So it's definitely a process. It's definitely a process.
Can you elaborate on how someone gets to be a conservator for another person? And is there any advantage or disadvantage to having it be an agency versus a family member to act as one's conservator?
So Diana has already talked about how her agency acts and they search for family members. Let me just touch a little bit more on that. Sometimes a family member is not, even if there is a family member in the area, they're not the best option because of an estrangement or because of just a breakdown in the relationship. So, I always think of Diana's agency. We have great respect in the private sector for the public guardian, the public administrator, because in my mind, the way I look at it is your office takes the tough cases, and they're all tough cases in some way or another for the people involved. But there are some really, really difficult cases where people just have nobody there, and this is what I'm thinking of, some specific cases that I can think of that have gone to Diana's office. The person who needs help doesn't appreciate the fact that there are people trying to help and rejects that help out of hand. And so the only people who can help without getting slapped in the face for it, and maybe the public guardian gets slapped in the face too in a bit, but they're not emotionally connected. It doesn't hurt them in the way it hurts a family member, is to have the public guardian involved. So I've been very appreciative when Diana's office has taken some of these very difficult cases, because it's every case is different. And when somebody needs conservatorship, truly needs it, they don't appreciate what's being done for them. They don't appreciate their own deficits, so they, by virtue of that, they don't appreciate the effort that's being gone to by other people around them. So oftentimes the public guardian is the best answer for that, and we are blessed in this county to have a very good public guardian office. And I'm not just saying that because Diana's sitting next to me. As far as how to, the question had to do how to become a conservator for another person. So you've seen these two forms. There is a petition form. So if we're going with numbers, it's the GC 310. Okay, the GC 310 is the main petition. That's the public petition where you say, here's the information about the person. Here's generally speaking what's going on, and we're asking the court to establish a conservatorship. There is also, that is general conservatorship, of probate conservatorship. There's also a temporary conservatorship option. Why do we have a temporary? Because it takes a while. Even in Ventura County, it can take 60 to 90 days for your case to be heard from the time you get it filed. What if there's something very urgent going on? Diana mentioned foreclosures. I mean, there's, especially in cases of elder abuse, there are sometimes pending home sales that you need to stop. Or something else that's just so exigent that we have to get in a quicker time. And so temporary conservatorship is an option. That's a whole nother petition. And you cannot file a temporary conservatorship without filing a general conservatorship petition as well. So sometimes there's just a whole stack of paperwork that has to be filed with the court. It's very labor intensive. It's very form and document intensive. But that all of that has to go to the court so that the court can make the findings that need to be made. As I've mentioned a few times, this is a constitutional issue of rights of the individual being affected, and so the judge has to go through a very detailed and established process to find that conservatorship is needed. Diana mentioned alternatives. She mentioned a trust, and trusts are one great alternative to conservatorship. And we may be able to touch on this more in a later question, but I just wanted to at least list ones that come to mind. And again, an easy way to look at the alternatives is to look at that GC 312 and look on page 3, because that's the list of alternatives the court wants to know about. So let's just go down that list really quickly here. Supported decision making is a new concept in California law. It came about after a certain high-profile case that you might have heard about in the last few years down in Los Angeles, having to do with a young lady who's a singer. We all know who we're talking about here, and so every time there's a high-profile case like that, and I know there's a question coming about this, so I won't get too far down in individual cases, but I just want to say those tend to cause changes in the law, often changes for the better, but not always. Sometimes the stick gets bent too far in the other direction. But in this case, the idea here with supported decision-making is another way to avoid conservatorship might be to have the court foster an agreement between the person who needs help and somebody who can help them, but not in an official conservatorship way, but just through an agreement between them that they're going to accept help informally through this process called supported decision-making. So it's a new concept. It's not fully understood or fleshed out, frankly, in my mind. And I was at a continuing education, with our judge in this county, and he had a lot of questions about how it would work. So I think that it's a great thing if it can work in certain cases, but I don't think it's going to work in a lot of them, because most of the time things have gotten so bad before we even get to the point of thinking about conservatorship. What are some other options? Healthcare surrogate. Okay, that's if I identify somebody orally to my doctor, or I'm at the hospital, can I just designate this person to make decisions for me? That's a healthcare surrogate. Again, that would be, the hospital will recognize that. That's a way to recognize agency for healthcare medical decisions. So if the person has the capacity to direct or to nominate a surrogate, that can be an alternative conservatorship. Advanced healthcare directives, powers of attorney. I'm going to group those two together, C and D, because these are documents, legal documents, that create agency. They give the ability for someone else to do things on my behalf. Different from conservatorship, because I never give anything up. I can always revoke those. I can always do those things myself. But to have help from someone else, I can have on medical, I use an advanced directive. Does everybody know what an advanced directive is? Raise your hand if you want. Okay. Raise your hand if you want me to explain more about what an advanced directive is. Seeing no hands, I will not. All right. And then power, a lot of you have been to other presentations, so you know about these. And then the power of attorney is more for the financial and non-medical things. So these are alternatives. And a trust can be an alternative, because anything, like Diana mentioned, Conservatorships and trusts are kind of on two separate tracks. And so just by getting a conservatorship doesn't give you authority over a trust. A trust is a separate entity, a separate thing that the court has to look at. So if all your assets, if your house is in a trust and all your savings are in trust, maybe we don't need a conservatorship of the estate. So it's an alternative. And then other alternatives, letter F there is just to opine about other efforts that have been given. Often I will touch on any other efforts to informally give assistance and how those have failed in that section. So those are alternatives to conservatorship, and I think it's important to try them if at all possible before we apply for conservatorship, because one of the things, another disadvantage of conservatorship is the cost. The cost of filing just the initial petition is $435. That's just the temporary, or the conservatorship petition. If you file a temporary, that will add to the cost. There's a court investigator that Diana mentioned. That cost, I believe, is about $600. That's passed on to the person who's petitioning usually. And then if a private counsel is appointed, that cost comes for that, to pay that attorney, comes out of ultimately the estate of the person. The court has to order that, but all of this costs money. And then just to prepare the documents and do all of that, my office would do that, and that's on an hourly basis. So even if we work as quickly as possible and we use paralegals who are expensive and experienced at this and not as expensive as the attorney, it still costs money. So if we can do anything to use an alternative instead, then we should. Did you want to add anything to the last question that Blair asked? Agency versus family member, I think, is the main thing there.
I just wanted to say that the court has frequently, and like Mr. Young, not Mr. Alvarez.
From the Alvarez It's a compliment. He's a good guy.
At any rate, when there's competing petitions, which happens a lot, brother wants to be conservator over mama, sister wants to be conservator over mama, and they fight, and the court's like, they even send them to mediation, and it's not going to resolve itself. So let's appoint public guardian as the neutral entity. So a lot of cases that we have, very huge involvement with dysfunctional families, very much so. And they just get more and more
Say that
complicated.
again. About the family, what was the word?
Oh, dysfunctional.
Oh, thank you.
Dysfunctional, yes.
Never heard of that.
Oh,
Never.
okay. Yeah. And, we are court-appointed fiduciaries, but sometimes we almost play like a mediator role, right? So we're dealing with family members who aren't in alliance with the care that we're giving to the conserved client. But we'll listen to family members, but really, as conservator, we are the conservator and for the best interest of our conserved client, not necessarily family members. So we always want to point that out. And placement is really, really difficult, especially with clients in dual diagnosis or a lot of these defendants coming down. They might have, they might be 298 registrants, and they might have aggressive behaviors. But we put them on a probate, and placing them is very difficult. And we don't have a lot of placement in Ventura County, so a lot of times, and especially with our LPS clients, they're being placed out of county. And we get calls all the time from family members. We want our son to be up here in Ventura County. We just don't have the beds here. We just don't have the placement here. And that is a problem throughout California. All the 58 counties in California, it's a huge problem, But I just wanted to talk
What's
about that.
dual diagnosis?
Oh, dual diagnosis is when somebody has psychosis, but then also dementia. So they might be bipolar and then they have dementia, right? So they have a dual diagnosis.
So they need additional.
Right, psychotropic
Right.
meds.
Okay.
So we might have somebody who, for example, we have LPS clients who we've had on conservatorship for 20+ years. And that's not unusual. And for 20+ years, they are being administered psychotropic medications, right? Different cocktails, all those years. And now they're aging out, but due to the psychotropic medications they're receiving, the onset for dementia comes earlier. So then we convert those clients to a probate conservatorship, and we ask the court that we have the authority to consent to psychotropic medications, because they still suffer from their schizophrenia or their psychosis, but now they also have dementia. So that's what I mean by dual diagnosis, right? So we also have cases where it's very difficult to determine what that person has, whether it is true psychosis or whether it's dementia. We have recently a 27-year-old who has Alzheimer, really early stage of Alzheimer. But anyway, so that's what I was going to say.
Very complicated. They go to the public guardian. And again, we greatly appreciate their experience. I do want to distinguish and disambiguate a few things. I can do that later, though, if you want to ask the next question or whichever you prefer. Okay. A few things that Diana has mentioned about, she talked about notice, so I want to touch on that. And she talked about locked, and I want to touch on that and explain that a little bit. And that, in my mind, comes under the pros and cons of conservatorship. And here's why. A lot of people, especially in memory care, wander. And we all hear about these, what do they call them, silver alerts now? Is this when, so, but we can all think of cases even very much, bless you, in our local county of people who have been lost because of wandering. So the way to handle that most people have found is through a secure perimeter facility. That's the legal term, secure perimeter facility. What does that mean? Sometimes it means completely locked down, but oftentimes it means what's called delayed egress. So if you push a bar on a door and it doesn't go anywhere, but then 10 seconds later it'll open, or 15 seconds, and meanwhile there's a silent alarm that went off behind the nurse's station or something like that, that's delayed egress. So they're not technically locked in, but boy, it's almost the same. Well, if you are in a conservatorship situation, a court has to order that is appropriate. And remember the term least restrictive alternative? Basically, a judge has to decide that senior jail is what that person needs, because that's really what it is. They cannot leave, or they cannot reasonably leave under their own wishes. And so if you look at the back page of the capacity declaration, that GC 335A that I mentioned, that top part is about whether the doctor advises that this is necessary. And the judge is very, very reluctant to grant these. Typically, you will have to show that there's a great and legitimate and active concern about the person wandering before they will do that. So, however, if you have a power of attorney and an advance directive, you are empowered to use something like this, and you don't have to go through that due process with the court. That can be viewed as good or bad, but the fact is it's much simpler for the people trying to help their loved ones to not have to go through that process and get a court order to allow them to be in a memory care facility. Almost every memory care facility I know has that at least delayed egress to avoid the issue of wandering. So these are very practical issues that come up in conservatorship, and yet another reason why I say use it as a last resort. With notice, Diana correctly said notice has to go to second-degree relatives. I have a chart in my office of consanguinity. I'm sure Diana has one too, where we're looking at, okay, there's the person, there's the first degree, and it's parents, siblings, children, right? Spouse, of course. And then second degree, we go to grandparents, grandchildren, right? And so oftentimes I get pushback from clients saying, well, why do I have to give the contact information and phone numbers and send a separate service packet to my 6-year-old niece, who's a grandchild. That's just the way the law is. And the court investigator needs to know who everybody is and have phone numbers for everybody, et cetera. I mean, they're reasonable. They're not going to ask a 6-year-old about whether grandma should be conserved, but they at least need to know who that person is and how to reach them if they do. So these are just some of the how to go about doing this. And you might be getting the picture, don't do this at home, because it's a lot of detail. And one of the saddest things when I do pro tem, when I serve as a fill-in judge, is I see cases where people have tried to go it alone and they get a delay in the case because they didn't know that they had to do this notice, or they didn't give notice to the grandchild, or they didn't do it right. To the point that if you say to grandchild, care of parent, that doesn't count to the court. You have to just say to grandchild. That's their packet has to go out to grandchild, even if they're a minor. Silly things that are not intuitive, but they are requirements. So I would say at least talk to the self-help if you're going to try this, but to avoid a lot of the headache and delay, maybe consider having an attorney that's involved, that knows this stuff and can advise you, so that you don't have those unfortunate last-minute delays.
I've heard on the radio, who knows, that LA was looking into putting some kind of bracelet or whatever for a tracking device for people who were escaping.
Have you heard about that?
Family or whatever, and nothing in Ventura County about a tracking device for people with dementia who wander.
Can I answer?
Yes, please. Blair will answer.
There actually is.
Yeah, there is.
It's called Project Lifesaver through our county, through the Area Agency on Aging and their collaboration with the sheriff, Ventura County Sheriff Department. There is a process and an application, and anybody who is caring for someone or knows of someone who is a wanderer or risk for wandering, that is a great additional tool to have, as well as an adult at-risk ID card. Having that on file with the sheriff's station, if somebody does get out, it looks and feels like a license, but it can get blasted to everybody who's on parole. So a BOLA will be on the lookout, and that also helps to return an individual in a much quicker time frame.
And I'm just going to make a guess, but I think that the distinction is that these are voluntary programs, not court-ordered.
Not court-ordered.
Right. So all of these are in the alternative sphere to the court-ordered situation where the rights are affected very dramatically. So, yes.
Mr. Young, you mentioned private attorney list.
Yeah.
Is that available, accessible on the internet, or how would we get that list?
Sure. When I mention a list of private attorneys, there's a list the judge has of attorneys that he appoints when there needs to be somebody appointed for the conservatee, as opposed to a list of private attorneys who just know conservatorship and can help bring those cases. Some of the same people are on both, or do both, right? Some private attorneys are on that list. Not all private attorneys are. We all are doing this in a way to try to give back. I personally am not on that list, but like I said, I do the fill-in judge work. So we're all trying to give back and help in different ways. But the list the judge has is something that just only he has. But I would say that we have a very good working list. I'll use this opportunity to plug, right now, over across in that building, because today's Monday, from 1 to 4, there's an attorney sitting there helping people right now. We have a clinic, a free clinic in this county at Camarillo Healthcare District. I'm honored to be helping to organize it and organize the attorneys, but there's about 14 or 15 attorneys who come one every week, Monday 1 to 4, and meet with people and answer their questions. They don't do drafting. They don't, that's a separate thing. They'll review documents, they'll answer questions. It's a consultation up to an hour. And so those same attorneys are often, I don't want to put words in Blair's mouth, but I would say if somebody came to her and said, I need a conservatorship attorney, she's going to give them that list, or at least the people on that list who do conservatorship. So it's a more informal thing, but there are lists out there, and I'd be happy if it's not something my firm, because we have a conflict, it's something that we could refer you to another attorney who does it. There are, I would say, a half dozen to a dozen very frequent flyers in the conservatorship court, private attorneys in the county that just do this, so yeah, no problem. Yes.
You both mentioned going as far as the second degree relative in this process and follow-up. Is there a responsibility of that second degree relative to assist the client, or is it just a part of the investigation?
There.
Yeah.
It's part of the notice requirements. They don't have to participate in anything. They don't have to go to the hearing. They will probably get a call from the court investigator, the probate investigator, and they can just say, I don't want anything to do with my dad. He molested me as a child and I have nothing to say. Click. So they're not going to be part of the investigation. But they have to be legally noticed. So for public guardian, there is no cost to establish a conservatorship. That's really coming out of all of our pockets, right, as taxpayers. But we do, if there is a lot of money in the estate, if the estate is large, we can go in and we have to have required documents, especially as conservator over somebody's estate, and they have a lot of money. We have to provide the court with an accounting, which can be very complicated just in and of itself. And at that time, we can ask for conservatorship fees. It's part of the probate code, so whether you are a private conservator or whether you are a public guardian as conservator, we can get fees. I can tell you public guardian's fees are a lot less than a private conservator, especially fiduciaries. So we do have a lot of cases that we might establish the conservatorship, but we'll nominate a court-appointed fiduciary who has more resources for very large estates, right? So somebody might have, millions of dollars where they've got investments in New York and all over the place, maybe 3 different residences and all of them are rented out like property management type stuff.
Sure.
That is not appropriate for the public guardian's office, but it would be more appropriate for a private fiduciary. I think in this county, I can name 2 or 3, not very many private fiduciaries.
So those fees then would come out of the estate of.
They come out of the estate, yeah. So with the public guardian, all the money that is being dispersed is coming out of that estate. So we can tap into what's called a revolving fund. So like I explained earlier, if we want to stop a foreclosure from happening and we need $10,000 to stop it, we can borrow from the revolving fund, but in the end, it's going to come out of the conserved client's estate, probably when we sell the residence.
And I'm going to touch on that from the private side. And you brought up thank you for bringing up private professionals too. So I will say this, as an umbrella point, ultimately, if there are resources in the estate of the person who's conserved, ultimately, if everything goes well and right and everybody does their job and acts in good faith, the court will most likely, and you're catching hedge words here because that's what attorneys do, right? We don't say this will happen. We know better than to do that. But the court should reimburse people out of the estate, okay? Whether it's the public guardian's office, even the public defender, who Diana mentioned, and I mentioned, handle cases that are of lower value estates. They still have the right to, and sometimes the justification to, for instance, if they later come into money, and they've been representing for years a person, they will say, you know what, we're going to put a request for fees, because ultimately these are our taxpayer dollars, and they have a duty, I would say, to try to recapture some of those into the coffers and use them for other people who truly have no resources. So they, as Diana said, the statute says anybody who's involved in the estate and involved in the conservatorship, there's sometimes it's discretionary and sometimes it's mandatory, but the judge will oftentimes have that person paid out of the estate of the conservatee. So the most likely scenario, if people have money, is that it's going to be their estate that pays it. And that's not necessarily a bad thing, because we're at, this is that person that needs help, right? And so it seems fair to me that it be their resources ultimately that pay. The problem is getting access to those resources, getting the court order, which often doesn't happen for a year or 2 down the road, and getting reimbursed. So it does take a family member. If you're going the private way, it often takes a family member willing to take the risk that that won't ever happen, or take the risk of at least putting their own money on the line to get things going. So that is the difference, a big difference there, because as Diana said, there's no upfront cost in your case, but for somebody who uses a private attorney, there are upfront costs. What that would be, it's just a function of how much time, how complex the case is to bring it, but it's not insubstantial. And I often say that, you know, the contrast between that and getting a good power of attorney, advanced directive, and trying to make those work, it's the biggest contrast I see in the law between, you know, in cost. You know, it's so much more expensive to go. It's not just getting appointed, but as Diana mentioned, there's accountings due at the 1, and then they go to every other year, 3, 5, 7, and so forth years. And those accountings each require somebody to make the accounting, someone to put a pleading on top of it and bring it to the court, attend the hearing, the judge will have questions. All of that takes time and money. So it is an ongoing process to have somebody under conservatorship. But I think that ties into maybe your next question, which is about, go ahead.
Yeah. Can you expand on who makes sure that a conservator manages a person's affairs properly?
The judge. Next one. Oh, just kidding. No. I just mentioned accountings. What's the point? Because one of the things, I'm sure there is a movie floating around on Netflix. I don't necessarily recommend it for other reasons, but the point is that there are things out there in popular culture that tell us all the time about abuses that can happen in conservatorship. And partly because of those abuses, the laws, I would say at this point, are quite comprehensive and protective of the rights of the conservatee in a way that seems rather onerous to good family members who are just trying to get the job done, but have to fulfill all these requirements of, you know, getting status reports and financial accountings to the court. The court, when they get an accounting in this county, reviews it closely. That's not the case for all other counties. Some other counties wait for a family member to object or somebody to come along and say, hey, that doesn't look right. But in our county, it's reviewed and scrutinized, and if there's something that doesn't balance up, they ask questions. And so there is a lot of scrutiny and protection, and so I would, you know, I was being glib about the judge, but ultimately it is the judge and the court in a conservatorship that makes sure, with the help of other people who are keeping an eye on things, the court investigator, family members who get that second-degree notice, all of those people are part of a team here to make sure things are being done right, that the money's not being wasted, that everything's being done to protect that person. So that's how that process works. But it ain't cheap. That's the flip side of it. So just keep that in mind as you're thinking about the alternatives and whether to go ahead with those. If you have the time and the ability to do that, I would recommend it.
I was just going to mention one other thing that I don't think has been mentioned before. But one of the requirements if you want to be conservator over somebody's estate is to hold a bond, and that's to protect the estate size. A lot of people with good intentions might not be able to acquire a bond, and there's a certain formula there. I think it's the income per year plus a 10%, which is the bond amount. So I really don't know much about in the private sector, but for the public guardian, we carry a $1 million blanket bond, so we never have any problem with that. But that's also one thing that the court has in place, and it's by the probate code to protect an estate from any mishandling, right? So in our office, we also have, besides the court's oversight on pretty much everything we do, we have 100% case audit in our office. So a couple of our managers goes over everybody's caseload, make sure that their Social Security benefits are being applied and followed up, and you know, all that good stuff with the person's estate. So we have that.
And I brought up, or I thank you for bringing up private professionals and then completely dropped the topic. So in our county, as Diana said, there are way too few private professional fiduciaries, but there are people with this job, and it stands, it's private professional fiduciary, PPF, you'll hear them called that for short. And they are, for the most part, good professional people. They are licensed through the state, okay? And they are bonded and insured, and they have a kind of a heightened scrutiny with the court to make sure they do things right. And they have a reputation to uphold, and so they are very protective of that. And so in cases where it's maybe there's too much money, I can think of one case in the last few years that comes to mind. The gentleman's passed away now, and he was written up in the Star because he had it was the largest gift to Cal State Channel Islands that they'd ever received. I think it was about $31 million. I don't know if you remember this case, but it was just in the last couple of years. But that gentleman needed a conservatorship. And Adult Protective Service, there was abuse going on from non-relatives, and the court appointed a private professional because he had a lot of money, a lot of resources, but there was nobody that the court was willing to appoint other than somebody who was licensed and bonded. So this private professional in our county, who I know and is very good at her job, acted as his conservator until he passed away. Point is that is a great use of a private professional fiduciary, somebody that they have the time, this is their job, they charge an hourly fee, but they are kind of a bridge between a family member on one hand, if there is no family member that can do it, or there's no family member appropriate or competent to do it, and the public guardian, which is for, again, you don't tip, I don't want to speak for you, but I would assume there's pretty much a financial threshold. If they have a gazillion dollars, you're going to say this isn't appropriate for our office, most likely. So private professional fiduciaries are a great option. Also, they oftentimes get appointed on a temporary basis just to help kind of sort things out. And then sometimes once things are sorted out and we figure out who the good guys and bad guys are, then the judge may appoint a family member at that point. But so it's not a permanent thing necessarily, but oftentimes it is. And unfortunately, there are not enough of them. There's a great need in this county, and every one of the private professionals that you asked would tell you the same thing. They are very, very busy. And so, if you have any friends or children or grandchildren who are looking for an honorable, but also a very difficult career, it's a good one, and we need more good people that do that. But private professional fiduciaries are kind of a middle ground for to act as conservator.
You kind of started to go into this with what has been represented in the media the last couple of years, even just within the last month. Can you discuss some of the common myths or misunderstandings about conservatorship or the process of obtaining conservatorship?
Well, yes, there have been some high-profile cases. One in our own county in the last, I would say, 10 years. A young lady who was a child actress who had a conservatorship. That conservatorship was, in the last few years, it was terminated. And so it wasn't as high profile as the case in Los Angeles, but it was one that got handled through our local court system, and I think hopefully successfully. With every high profile conservatorship matter that gets into the media, there's a lot of misunderstanding, and again, some of the popular culture and the movies and things like that don't help the situation. So I think there's a lot of misunderstanding as far as what conservatorship is. We've talked about how it's primarily for developmentally disabled, gravely mentally ill, or people with dementia toward the end of their lives. Pop stars are not your standard conservatee, so there have to be really extenuating circumstances for those conservatorships to even come about. And it's not unusual to see them terminate. Now, we don't necessarily have people protesting in the street with Free Britney signs, in every case, but it's not uncommon, as was the case here in our county, to have them terminate at some point. Somebody gets a little more maturity, is able to manage his or her money better, and then they can go on their way. So the main thing to keep in mind is that, I alluded to it earlier, I see the good in people in conservatorship. I see conservatorship as a last resort, but it's often people who just very much care for their parent or their loved one or their child and are trying to help them, and they have no other option. Diana did mention, and I haven't touched on it too much, but there is also the fighting family, the dysfunctional family situation where they can't agree on who's going to help them. And certainly I have my fair share of those cases, and I have a perfect track record of always representing the good child. For any of my clients that are watching, no, that's true. I'm blessed with in many of these cases the reasonable party, but it's not it's tough for the judge to sort these out. So oftentimes they'll appoint a neutral person, at least temporarily, to get it sorted out. But I would say the biggest, there was one case, it was about 10 years ago, and it had to do with Casey Kasem. We all remember him, right? Casey Kasem was a really tough case, and I knew some of the attorneys involved in that one. But what came of that was a really good change in the law. After he passed away, the assembly changed the conservatorship laws, and there was a misunderstanding, or there was a lot of gray area when it came to who could visit somebody and who could speak to, and whether the conservator could control the phone calls and the mail and the visitors of a conservatee. And that all got changed after the Kasem case, to the point that you have to have a specific court order now in order to control those things. And if you don't have that court order, then you cannot limit somebody's visitors. You have to go through that process. You can't isolate them from family, even if you don't like that family member. So I would say that the high profile is a double-edged sword, because it kind of gives conservatorships a bad name in some ways, but it also tends to bring about good, positive, needed changes in the law. And that's one example right there. How about you?
I was going to comment on that Netflix film, I Care a Lot. I don't know if anybody saw that, but one of the big myths on that is that there's no due process, right? Somebody can be concerned and they've never even been to court. So that doesn't happen, right? So there's laws in place where Judge Lund, who is the probate judge in our county, will not establish a conservatorship without having his own eyes on the proposed conservatee, even if that proposed conservatee is in a hospital bed and can't talk and doesn't really understand the proceedings, he still needs to see that person.
And that's one of the very few things that were good about the last few years and all the lockdowns, is that we have virtual court. It's much easier to see those people now. Whenever you go to court, in the courtroom 6 over on Vineyard, easily half the cases, if not more, involve people up on video screens from a home, from a hospital, from a assisted living facility, wherever they happen to be, and they're zooming in for that hearing. And then the judge has the benefit of being able to see them, put eyes on them, communicate with them. One of the hardest things about Friday mornings was getting all those people to court at 9 o'clock. For a lot of people, that was really tough. Still, a number come, but it's not always necessary anymore. So that makes it the access to justice is a little more available there. So, and I agree with you that due process is a huge concern, especially in our county. And I would say all the counties where I practice, they put a lot of effort to make sure that people, are heard and have an opportunity to object, and then the judge makes his or her decision. So that is something that is good about these laws. Anyway, so just keep that in mind. But again, something that's not always represented in in the public as much.
So back to your power of attorney questions. If someone has a trust and then they have a health power of attorney and a financial power of attorney, is that enough to negate having to get a conservatorship at some point?
It was a great question, and it said if we have the power of attorney and the healthcare directive and maybe even a trust, can we avoid conservatorship? And this gets to the crux of the difference between those documents and conservatorship, and that is, remember I talked about rights? A conservatorship is taking the rights, certain rights, away from somebody. The documents that you just mentioned do not, and this is a misconception I see all the time. People think, oh, I don't want to have a power of attorney. I don't want to give up my rights, to go to the bank and do things. That never happens. If you have a power of attorney, you're sharing. If I gave Diana my power of attorney, she could then go to the bank for me, but that doesn't stop me from being able to go to the bank. I can always go to the bank too, and if Diana, forgive me for what I'm about to say, if she messed up for some reason, I could fire her and get another person. That's just the way powers of attorney work. With conservatorship, the judge makes the decision. He substitutes his judgment for you, and your right to do these things is gone. When you're in conservatorship, you cannot. I mean, I have conservatees who call the bank. wanting to move money around. And for very good reason, they are not allowed to do that. It also gets to a case that the last question that you left off was, was about a particular case that we might have thought of. And I was thinking about one, which is right down the line here. So let me just say, it was about a gentleman who's had all those documents, and his daughter was his trustee, and his daughter was his agent under the power of attorney in the healthcare. And he would go down to Wells Fargo, and he'd open a new account and move $100,000 into it and promptly forget. And there'd be panic. Where did the money go? And that's a classic case of where those documents won't work. They work almost all the time, but they might not work in that case. We had to go to court and get a conservatorship so that he wasn't able to go do that. Because even though he had done all best laid plans, right? But though he had done that, he wasn't able to, it wasn't working. He needed a conservatorship. So does that answer your question? Okay. So it's a sharing with the documents or a taking away and vesting in another person with a conservatorship.
Perfect.
You, sir.
Yes, I noticed on the front page of that form, the GC 335, about capacity declaration. In that first box, it talks to the physician, psychologist, or religious healing practitioner, which is defined a little bit further down under 3B. And I don't think I've ever seen it in any other official document, and I wonder how often does that element arise in your experience?
Never had it.
Neither of us has ever checked that box.
Never.
I'm going to say that box has probably been checked by some people, but it's never been checked. But there are faiths, and I'm not familiar with them personally, but I know there are faiths that do not believe in medical science in the way other people do. And so this is an accommodation for those folks, okay? To give them a way to give a declaration to the court without necessarily having to go to the doctor if there's somebody qualified. So I have never had personal experience, so anything I said beyond that would be not worth much. So I'll just say that that's what the purpose of that was for.
Well, I also do know that there are certain, you want to call them cults or religions, that have a great deal of control over the individuals. And I don't know if they qualify as a legitimate faith or what. And I'm just wondering if that ever surfaces.
I haven't had it surface for me. I'm sure it comes up, but there's that control issue is coming up in all sorts of contexts, and that's why the judge gets to be the judge and determine whether the information being provided is correct or whether they're going to rely on it or not. So I think that would come under that category. Not all the information provided to the court is taken, with at the same amount. The judge has the discretion to say, I'm not going to give a lot of credence to that particular thing. So I think that's how that would be looked at. Any other questions?
For the public guardian, I ran nursing homes for a number of years, and we would get patients who were admitted, no assets, no family that we could find, and we'd come to the public guardian's office, and they would say, not our case. And so the skilled nursing facility is sitting there, whether the issue is unpayment of a bill or other issues in terms of placement, but basically with no intervention. And I'm just curious, I'm assuming that's still the case, is there, or has a better solution materialized in recent years?
So we get a lot of our referrals from skilled nursing facilities, and we would never say we don't want to get involved, right?
Right, but,
Or it's not our client.
okay, so let's say it's your client,
Right.
but would you end up actually processing conservatorship? Because at least part of my experience was this person was housed, fed, monitored, so part of the criteria that you've used
Right.
you can't mark those boxes because they're in a licensed facility.
That's true. However, most of our cases were conservator over estate and person. So over person, we would make medical decisions. So even if they are in a home, a lot of our conserved clients who we have conservator over person are in a skilled nursing facility. So we still have authority over them, over their person, to place them if they would need a different type of treatment or care.
But in terms of, so you would accept them as a client and go
Yes.
through the process
Right.
of getting them conserved,
Right.
however long that
Mhm.
takes. Okay.
Yeah.
When you mentioned the number of cases that you
Mhm.
have, we're in a county with roughly almost 1 million people. 28% of us are in the demographic of over 65, and you have 140 cases. So I guess
Right.
it seems like a really small number.
It does seem like a small number. It is increasing. It's just going up and up and up. I would say probably 12 years ago, we had maybe 55. So there are a lot of private conservatorships in place. There are a lot of individuals just taking care of the older population. So we are the last resort, and our first thing is to find alternatives. But it is rising. APS, Adult Protective Services, now their elder abuse has gone down from 65 to 60. So we're seeing a lot more referrals from APS. So I think that it's just going to keep going up and up with the aging population and also the age requirement. It's just, we're seeing more cases. We're getting appointed by the court a lot more. But what happens is we might have a lot more cases, but a lot of cases we're being appointed on people who are very old. I mean, we've had somebody 102 years old. Their life expectancy, folks, is not going to be 10 years, chances are. So a lot of our cases, we deal with conserved clients who pass on. So right now we have about 140, but just last month we have 10 conserved clients who passed away in our program. So it's constant like that, if that makes more sense.
You might say there's high turnover on the conservatorship roles. That applies not just in the public guardian, but we see that as well. I would say that demographics are a big factor, and yes, I see more, but I see more in the last 5 to 10 years, more also because just the demographics of the county, population in general, and the age of the population. But also, if we're doing our jobs right by coming here today and talking about alternatives, we're trying our best to help you avoid conservatorship. I mean, that could be the title of the of the talk, is how to avoid conservatorship. Yeah. And I'm constantly doing that all day long. Can we do this? Can we try that? Is there anything we can do? And that's because it is the last resort. And then Diana's agency is the last resort of the last resort. So that's why her numbers are what they are. But if we can do anything else, and I think the law recognizes that, and that's where the supportive decision making comes in. That's where that whole scrutiny of what other alternatives have been tried comes in. If we can do anything to avoid conservatorship, we will. But it's there if you need it. You should know about it. But the main reason to know about it is to tell everybody how much they should do everything to avoid it, I think, and be an evangelist about that, because it is it's a burden. No matter how you cut it, it's a burden on those trying to help their loved ones. So, any other questions? Oh, yes.
Special needs trust.
Special needs trust is a different topic, which I'd be happy to talk with you offline on, but special needs trusts I will just say this, are a way to leave money to someone who has a disability. And let me just say, it's another way to avoid conservatorship. Because if you have a disabled family member and you want to leave them the benefit of an inheritance without giving them cash outright, you can do something called a special needs trust. Talk to me if you want to know more about that. And then it's less likely that there will have to be a conservatorship of the estate for them later on. okay? So it's another tool to avoid it. But we can talk, if you have questions about how to get one set up or what to do with those, if someone's on public benefits and they're receiving Medi-Cal, if they're receiving SSI and they are about to inherit money, that will, in many cases, they'll blow up their benefits, especially the Social Security benefits, if they don't have a way to have that money held back in trust so they get the benefit of it, but they don't have the actual money in their hands. So that's what, so on that hand, thank you for bringing it up because it's a very important tool. But it's just one more way to avoid conservatorship. So the question was, can a family member, like a daughter, act as a medical surrogate? Legally, yes. Legally, yes. But it's also up to the practitioner whether, so I mean, the practitioner has the right to accept an oral designation of a medical surrogate or just a family member, but sometimes for their own protection, they may have a policy of needing something in writing. So often those same practitioners will hand you a form, a statutory form or a California Medical Association or something like that and say, here, fill this out. So, and the most important thing those forms can do is just to name somebody as your agent. There's other options on there, but if you just name who you want to make the decision, sign it, have it witnessed, then you're often in much better shape than you were, right beforehand. So, but yeah, so legally, yes. But is the practitioner, as a private practitioner, do they have the right to set their own policies? Also, yes. So, yeah, no problem. Any other questions in fact? So the question was again about special needs trusts, and I'd be happy to do a topic or a presentation on that because there's a lot to unpack in your question. What I would say is this: when you when you have an inheritance, you want to leave somebody with a disability, leave it in a special needs trust and leave a trustee, someone else, in charge, and they'll make the decisions. And you can set it up very customized to that family's particular needs. But the main thing you can't do is give the person with the disability the control, or it will completely defeat the purpose. But thank you for bringing it up because I can't talk enough. I educate other attorneys about special needs trusts. It's such an important thing to talk about. So thank you both for bringing that up. All right, any other
questions? Thank you so much for your time.
All right, thank you guys. Thank you. Appreciate it.